Testimony training video by Braneeshia Veal. So we'll start with the 3 phases of testimony and what they actually encompass. So the testimony of a forensic expert is typically structured into 3 different phases. We have voir dire, direct examination, and cross-examination. So during voir dire, the expert's qualifications are evaluated. Attorneys aim to establish the expert's education, training, expert experience to demonstrate credibility. This involves presenting the expert's credentials and answering questions that probe their expertise in the subject. It is not just about listing qualifications, but also demonstrating confidence and clarity under scrutiny. Next, we'll move on to direct examination, where the attorney who called the expert elicits opinions and findings relevant to the case. This phase allows the expert to explain their methods, data, and conclusions in a clear, concise, engaging manner to persuade the judge or jury. So during this phase, the focus here is delivering an accessible explanation that connects scientific evidence to the case's broader context. Then we'll move on to the cross-examination phase, where opposing counsel seeks to challenge the expert's findings, credibility, or methodology, often through strategic questioning designed to expose inconsistencies or biases. This phase is inherently adversarial, requiring the expert to handle pointed or tricky questions designed to create doubt without overstepping their expertise. And this is according to Einwinkel 2015. Next, we'll be discussing what happens when we do or do not communicate with the attorney before trial. So personally, I think preparation for trial can vary depending on whether the forensic expert communicates with the attorney beforehand. And personally, I would suggest communicating with the attorney beforehand. Now, if communication does occur, the expert should discuss the case in detail, review all relevant reports, and align their testimony with the attorney's strategies. This gives you the opportunity to go over those opposing questions, cross-examination questions that could possibly happen during trial that you will now be better prepared for since you communicated with the attorney. However, without such communications, a forensic expert should independently review the case and all of the case materials. They should rehearse those anticipated questions and ensure their testimony is impartial and based solely on professional findings. It shouldn't be biased or opinion-based whatsoever, because during cross-examination, the opposing counsel is going to hit you really hard with that. Experts should also familiarize themselves with courtroom procedures and decorum to minimize surprises. And regardless of the preparation method, thorough knowledge of their work and a professional demeanor have to remain crucial. And this is according to Neal and Brodsky 2016. Next, we'll be discussing why can the attorney object to opposing counsel questions. So objections serve as a tool for attorneys to protect their fairness and relevance of courtroom proceedings. An objection may be raised if a question assumes facts and not evidence, effectively misleading the witness or the jury. Attorneys can also object if a question is speculative, requiring the expert to guess or hypothesize outside of their area of expertise. For example, and I just saw this the other day on a criminal trial case, they were discussing latent shoe prints, and that person was an expert in digital forensics. So that person was not able to give their opinion on that, and the opposing counsel did object. Other reasons include improper phrasing, such as asking argumentative questions meant to provoke rather than clarify, or presenting cumulative evidence that unnecessarily repeats prior information. Objections ensure that the testimony remain focused on the facts and adheres to procedural guidelines. And this is according to the Federal Rules of Evidence 2023. So let's get into compound versus leading questions. Compound and leading questions are common tools used by attorneys to direct or confuse witnesses. A compound question might conflate multiple issues, requiring the expert to provide a fragmented or unclear response. So, for example, the attorney might ask, "Did you analyze the evidence and conclude it was inconclusive?" So, before you answer that question, you should use 2 actions, which would be to pause and then seek clarification, or you can address each component separately. Now, these actions, according to this attorney, did you analyze the evidence and conclude was inconclusive? They might not apply to each other. So, of course, if you analyze the evidence and determine it was inconclusive, there would be no need for you to use it in court. However, they're asking you these questions together, which makes it a compound and also misleading question, but it is a compound question. Now, leading questions, often phrased to elicit agreement, can subtly influence responses. These might include suggestion phrases like, "You agree that this method is unreliable, don't you?" So, of course, if you utilize a method, you wouldn't want to agree that it's unreliable because then it would be inadmissible. So, to counter, and it's also going to affect the jury. So, to counter that, the forensic expert should restate their position confidently and focus on their findings rather than agreeing with implied statements. So, this is according to Neal and Brodsky, 2016. So, there are ways to enhance your direct examination process. And this can involve the forensic expert being strategic in how they present their information. Instead of merely framing the evidence in a way that captivates and informs the jury, you can add analogies, you can make it a storytelling technique. Relatable examples can also help demystify the technical topics, because we do include a lot of technical topics in forensics that goes over people's heads a lot of the time, and especially the jury. It kind of feels like they're sitting in class, and in order to get them to understand what you're saying, you can always, instead of just framing the evidence in fact, we can always make it a story. We can always add pictures or graphs or charts or visual aids to aid in this process. Also, the visual impact with the verbal testimony really hits juries and judges. When you maintain eye contact with the jury and use confident and natural body language, and further engages them, and it reinforces their credibility and authority. So this is according to Winkle-Reed, 2015. So let's discuss the goals for cross-examination. Opposing counsel's primary objective during cross-examination is to create doubt about the expert's testimony, the expert being you. This can be achieved by isolating minor inconsistencies and amplifying their significance to undermine the expert's reliability. So, for example, let's say you did answer those opposing questions, those leading questions where they were like, "You agree that the evidence was unreliable, don't you?" If you would have agreed to that, that little minor inconsistency right there would have undermined your credibility and reliability. So they may also attempt to show that the expert's conclusions rely on assumptions or incomplete data. Hence that compound question that I threw in there about you analyzed the evidence and your findings were inconclusive. This again decredits the expert that's on the stand. This is implying that their analysis lacks objectivity. Another tactic would be to frame the expert as biased, suggesting that their involvement is influenced by financial means, loyalty to the hiring attorney, racial bias, gender bias. Anything of those nature can be considered bias, and they can use it to exploit the expert on stand. These strategies erode the jury's confidence in the expert's findings, as well as the judges a lot of the times. And this is according to Neal and Brodsky, 2016. So how do you think you reduce that vulnerability during cross-examination? Well, a forensic expert can protect themselves during cross-examination by approaching each question methodically. Taking a moment or a pause, like we discussed in that original topic, to consider the question before responding can prevent impulsive answers that might be misinterpreted. Again, agreeing to those little leading questions can discredit you. Answering those compound questions without thinking about it thoroughly can discredit you. You doing any kind of bias or using any type of biased language can discredit you. So it is important that you get on stand and you're confident and you are sure of your answers and you are positive of your findings, of your results. If you have those visual aids, you have that storytelling method or any method that you use that will work for the forensic community, but also would and not discredit you, but also give the jury an understanding of what you're discussing and give the judge an understanding of what you're discussing. When you're confronted with aggressive or misleading questions, maintain a calm tone. Don't get upset. Maintain your demeanor, your professional demeanor. And, it's essential to preserve that credibility. Experts should also avoid speculating or addressing topics outside of their expertise. So if the opposing counsel brings up anything that's outside of your specific topic, you don't discuss that with them. You bring that right back to your initial findings, and you bring it back to, well, this is not my area of expertise. However, XYZ is my area of expertise. So you can also practice active listening. It ensures that responses are precise and aligned with the questions being asked of you. It reduces opportunities for mischaracterization by opposing counsel. By staying factual and impartial, that is the best defense against potential attacks. And this is according to I'm Wiggle Read 2015. So that's it for my training video, guys. Please let me know if you have any questions. I also have references, which I'm going to tell you now. So I have the Federal Rules of Evidence 2023. I've got I'm Wiggle Read EJ 2015 and Neal T. and Broski S 2016. For any additional questions, you're more than welcome to send me an email.